eager for more learning? Amazing. Okay, I have the pleasure of introducing Tia Workman and Jackie Tate for the next session. So Jackie Tate has been a BC public notary since 2013 and operates a busy notarial practice in Chilliwack, where she leads a team of 8 staff members. Prior to being commissioned as a BC notary, she spent 20 years working as a conveyancer and office manager in a notary practice, giving her a strong foundation in both notarial work and practice management. Jackie has also been actively involved in the profession, having served on the board of the BCNA as Secretary-Treasurer since 2019. Throughout her career, Jackie has enjoyed sharing her practical experience and mentoring notary students with a particular focus on preparing them for the realities of practice. Outside of work, she enjoys spending time with friends and family, cooking, traveling, and shopping. Before I read the next one, I'll ask you both to come up here and take your seats. You got this. Tia Workman is a British Columbia notary public with more than 30 years of professional experience with a particular focus on personal planning. Prior to qualifying as a notary, she worked for 10 years as a conveyancer and legal secretary, developing a strong foundation in legal practice. Tia was actively involved with the Society of Notaries Public for many years, including service prior to her election as a director in 2000. Over the years, she contributed to numerous committees and mentored many new notaries. Her leadership roles included serving as chair of both the audit and discipline committees, as well as second vice president of the society before stepping down from the board in 2010. Today, Tia continues to support the profession as a practice inspector for the Society, drawing on her decades of experience to promote professional standards and best practices. Outside of her professional work, she enjoys spending time with her grandchildren, singing with the local rock choir, and traveling as often as possible. Over to you. Thank you.
All right. Good morning, everyone. Thanks for joining us on this lovely Sunday morning. Those of you who know me well will know that hell is very cold this morning. So Marnie and Kwong stole our thunder a little bit yesterday when they pivoted from an affidavit discussion to a will. So much of what you're going to hear today is going to be duplicated, but hopefully that means it'll stick with you, and perhaps that's not a terrible thing. So whether you're new to this area or have decades of experience, the goal today is to provide a candid, practical look at what it means, what's actually happening in files, what's working, what's not, and where risk tends to concentrate. We hope to combine practical insights with real-world experience, so this stays relevant to what you actually see in your practice. By the end of this session, you should have a much clearer understanding of where the real risk lies in personal planning files, not just in theory, but in the kinds of deficiencies that are actually identified during inspections.
You will also be better equipped to recognize early warning signs. So those indicators in wills, powers of attorney, and representation agreements that tell you a file may require more attention, more documentation, or a different approach altogether. We're going to spend time strengthening how you interview clients and how you assess capacity in a practical, defensible way. And finally, we'll focus on implementation. What you can do starting immediately to improve your workflow, reduce risk, and ensure your files are inspection ready. This is meant to be practical. The goal is that you leave with changes that you can actually make in your practice.
So we're going to start with the inspection lens. What actually goes wrong? When we review files during inspections, what stands out is not always isolated errors. It's regular gaps in processes, particularly around documentation completeness, use of checklists, and file evidence. The same types of deficiencies tend to appear again and again across practices and experience levels. We use a file review sheet for each type or type of file during the inspection, and results from those are compiled and form part of our inspection report to the Society. So we've got our personal planning one up on the screen for you. Any rule breaches or recommendations based on the best practices are relayed to the member and then followed up on by the Society. I've gone back to pull information from the 195 files I've looked at to summarize my own experience as a practice inspector and to pull out the most common issues identified in the practice inspections that I've conducted. That button. So with common issues identified, documentation of instructions is where the majority of files fall short. Members are often either not using standardized checklists and intake forms or not retaining them in their file, particularly with respect to powers of attorney and representation agreements. There's often a lot of information missing, most information missing. This points to basic control breakdown. Checklists are there to catch exactly these types of issues showing up elsewhere in the data. When intake forms are used, they're regularly not fully completed. Some offices have very good intake forms. I have permission, wherever she is out here, from Wendy Shum to share hers if anyone needs one. But members often don't make good use of them, which leaves questions for a third party reviewing the files later. For instance, taking detailed information regarding assets is an area often skimmed over. This is an important capacity indicator, not just so that you understand what assets they have and how they hold them. It also gives you a greater understanding of what kind of advice you might need to give to your clients. When there's changes to instructions, we often don't see a clear record of those changes, of what the client originally wanted, how those instructions may have changed, or why certain decisions were ultimately made. This is also a high-risk gap. If due diligence is missing, it can make the file harder to defend down the road. I've reviewed files where the will specifically indicates that there's no children living or deceased, but there was absolutely nothing mentioned in the instructions about there being any children. Alternate executors or beneficiaries named in the will where there's no notes, or even a record of an email from the client where they've made those changes. Executors or beneficiaries are swapped around on execution day with no notes. Powers of attorney where the instructions say they're to be joint, but the document shows them as separate attorneys. Basically, you get the gist. Another common significant concern is a lack of meaningful notes. Marnie talked about that yesterday, and you're going to hear it again and again today, particularly around capacity. It's not uncommon to see a fully executed document in the file but have no real record of how the notary satisfied themselves that the client understood what they were doing. That gap becomes critical if the document is ever challenged, and even more of an issue when that client is elderly or there may have been someone helping them. Wills variation issues is another area that's not being well documented. Often there's just a note saying that someone is being left out, but there's no real discussion around it that can be ascertained by the notes in the file. I had one review recently where there was a 79-year-old gentleman who was doing a new will 2 weeks after his spouse died, leaving out all 6 of his children and giving everything to his stepdaughter, and there were no notes in the file. Missing core file documentation. Files often lack the basic supporting documents like title searches, wills notices, reports to the clients, account documentation, or where the original will is going to be kept. ID is not consistently kept in files or is such poor quality that it's of little use. You have to actually be able to see the picture. There are basic requirements for best practices, but they're not always handled with the same level of care as the document itself. They help demonstrate proper due diligence. Another somewhat common issue is the continued use of outdated precedents. WES has been around since 2014, but a lot of offices have yet to update their precedents, or they use an interesting combined version. Wills, best practices would be to use the will as an annotated guide to update those will precedents. I also see a lot of documents with poor wording, numbering, or formatting that are often reused over time without being updated or corrected into the next document. Like subparagraphs that use lowercase letters with the next paragraph using capital letters, next one using numbers, all in the same document. While problematic or outdated precedents are pointed out to members in their inspection report, those items are seldom or often not corrected. The onus is on you as professionals to ensure that the documents you prepare comply with current legislation and that they make sense. Just because a specific document has been used by you or for another member for a long time, just because it's out there in the community, doesn't mean that it's necessarily a good precedent. Clients are paying good money for these documents, so they should not only be well done, but they should also appear professional. There's also a heavy reliance on boilerplate language. Clauses are inserted because they have always been used, but not necessarily because they're appropriate for that particular client. So the document looks complete, but it doesn't actually reflect the client's circumstances. This includes clauses such as a receipts clause for organizations where there are no such gifts, a minors clause where the entire estate is being left to charity, or a remuneration clause setting out a specific amount to be paid to a trustee where there's only one executor who is also the sole beneficiary. I had one member advise me at one review that they were instructed to throw everything in the will, as it was better to include everything than miss something. I disagree. Powers of attorney are often drafted with all the clauses, with nothing in the instructions to confirm that these clauses have been discussed with the client or approved at the time of the initial appointment, but we'll chat about that more later. Some of the other drafting issues we see is those boilerplate clauses used without modifying them for the file. For instance, stating that the estate is divided into equal shares as follows, and then giving 90% to one person and 10% to the other. Or to divide, pay and transfer the rest and residue of my estate equally to my sister, where 100% is actually going to the one beneficiary. So make sure the wording actually works. Read it out loud. Also known as, make sure you use those if applicable. There's been many files I've reviewed where the AKA is used in the will but not the power of attorney. Or quite often it's used in the document but not in the signing line. And from time to time, the trustee or the attorney is also referred to with an AKA. Use consistent, correct language. I had one will I reviewed with a clause that read, provided he survives me by a period of at least 30 days, the residue of my estate is to go to my son John for his own use absolutely, subject to the following. Jane is to be appointed as the guardian of the person, and estate of the child John. And I wish my trustee to dole out the child's inheritance to the guardian for the use of the child in as often as the guardian sees fit. Read them out loud. Make sure they make sense. With representation agreements, remember that Section 13.2 of the Act requires that the representation agreement document itself must be signed by the adult and the representative. You can't simply attach a certificate of representative and call it done. Also, as an aside, don't try and fix your file the day before we come or the day we're there. We can see the date on that title search. So moving on to regulatory consequences. When issues are identified in files, the consequences can vary, but they're not insignificant. As a starting point, you might be asked to complete a corrective action plan, basically setting out the changes you're going to make to your processes to fit the issues going forward. If the issues are repeated or more serious, you may be subject to increased scrutiny in future inspections. Your files are looked at more closely, and expectations are definitely going to be higher. In some cases, deficiencies can lead to complaints or referrals directly to discipline. Beyond the regulatory process, there's always the risk of civil liability. If a document fails or is challenged, the file becomes central to that dispute. What's really important to understand is this. These outcomes are rarely the result of bad intentions. They're the result of weak files. Files that don't clearly show what was done, if it was done, how it was done, and why.
So tell us, Tia, what file did you review that made you the most concerned?
I don't know that there's really just been one file. It's really careless work that tends to get to me. Precedent errors carried forward in every document, misnumbered paragraphs, spelling mistakes, leaving multiple versions of a clause in a document rather than picking the one that actually applies. Using different fonts in a couple of paragraphs in the middle of a document. In one case, not actually leaving the residue to anyone. So you really do have to double check your work before it goes out there.
Okay, so now we're going to move on to risk indicators and personal planning. So first off, red flags in will drafting. Most disputes that lead to potential claims can be avoided by being alert to the warning signs that may be apparent either at the outset of the file or at some point during the process. I'm going to address a few of the common red flags and suggest some best practices that might mitigate the associated risks. So first of all, last-minute changes due to family conflict. So very common, of course. We've all experienced when a client reports a recent falling out with a child or another beneficiary and says, I want to take them out immediately.
Yeah, like my 79-year-old gentleman.
Exactly. So more than likely, these are emotionally reactive instructions, and the client has not given themselves reasonable time for reflection. There could also be a potential of influence by other family members. The best practice is to slow the process down. Ask, has this been a long-standing intention or something recent? If the answer is something recent, consider suggesting a cooling off period before meeting again to revisit their instructions. So Tia, maybe give us an idea of what you might say to a client in this situation.
Oh, I'd simply say this is a big decision involving family. It's worth taking some time to think it through before signing off. Don't need to rush into anything.
And speaking in general of changes, I always ask clients to bring in a copy of their current will. When I identify any changes, I take the time to explore the reasons behind them. And a lot of times clients will arrive without a copy of their current will, but I always ask them to either email it or come back and drop it off, and then ensure that a copy of that is retained in the file. Next, unequal distributions without documented rationale. So unequal distributions are not inherently problematic. The risk arises when the file doesn't explain why. So, for example, when one child receives the home or receives nothing or receives significantly more than the other children, courts are often going to examine prior gifts, caregiving roles, financial need. So the best practice is to thoroughly document the client's reasoning. And this documenting should be done either during the meeting or as close in time as possible. Just make sure the details are fresh in your mind and you're recording them accurately.
Yeah, it can actually be really helpful just to grab your phone and dictate some quick notes to yourself that you can send to yourself to flesh out later, but it's a good way to keep that quick in your mind.
Absolutely. And then, of course, next, the classic blended families and second marriages. And, the fact pattern that Marnie and Kwan talked about yesterday, it was a good example of this. So these files, of course, do frequently produce disputes, as they explained yesterday. Common sources of friction are children from prior relationships, the expectations of stepchildren, and the division of assets among the spouse and the children. So the classic scenario, right, is when a client says, I want to provide for my spouse, but ultimately the children should inherit. So best practice is to discuss the potential solutions and refer your client to a lawyer if the best solution for that client is outside of your scope, such as life estate or spousal trusts and remainder beneficiaries. Exclusion of children without explanation. So obviously, complete disinheritance is a major litigation trigger. Common scenarios we hear all the time are estrangement, substance abuse, prior gifts.
Yeah, I've actually had more than one client who over the years only want to include their biological children in the will, not their adopted children, which always I found quite difficult because I'm adopted, so I get my back up a little.
So best practice is to encourage clients to record a clear explanation, either in the will itself, and if you had Peter Ramsey as one of your instructors during the SFU course, he would have told you, do not do this. It just stirs up a hornet's nest. So you could also do a separate memorandum made at the time of the will.
Yeah, so I apologize to those watching from home, but just out of curiosity, as a show of hands, does anyone refuse to do a will where there's a complete disinheritance? Ooh, quite a number of you. Okay, yeah. Interesting. All right.
Okay, so now we're going to move on to powers of attorney and risk indicators there. So first off, broad gifting powers without safeguards. So Tia touched on this a little bit when she talked about the use of boilerplate language in our documents without, properly considering them. So broad gifting powers if they're inserted casually without careful thought, it can create significant risk. So you should be canvassing and evaluating the need for each client. So, for example, does tax planning require it? Tread really carefully here and consider who benefits from this gifting power. Are limits imposed? Is gifting allowed to the attorney themselves? The best practice is to clarify whether the client truly intends such authority, and most importantly, give them food for thought. So pose potential scenarios where these powers could be abused or result in unintended consequences. In my opinion, these powers should be used in very limited circumstances.
Yeah, again, going back to what I mentioned previously about powers of attorney, including all the clauses. I mean, there's clauses. There's so many powers of attorney where the clauses include transferring real property to themselves, making support payments for children even if they don't have any, reorganizing their affairs, appointing a substitute, which I always find kind of mind-boggling because we know so many of our clients have such a hard time even coming up with one person that they trust, that they'd even be willing to make their power of attorney. So to give that person the ability to just throw another person out there and let them take over, it just really throws me that they would want to give someone that power to do that in the document. Making donations of any assets to any charity at their discretion, to invest in any investments not limited to authorized investments. But probably my favorite is to receive gifts or loans from any of the donor's assets. So, if my attorney in my attorney's absolute discretion has reason to believe that I would want to make such a gift or loan to my attorney, pretty broad powers.
Indeed. Okay, next, immediate effectiveness versus springing authority. So as we all know, many clients misunderstand when the document becomes effective. So these two options are a balance of convenience versus potential misuse. Immediate authority is convenient, but it is vulnerable to misuse. But springing authority provides the safeguard of requiring proof of incapacity, but may create delays and tie the hands of the attorney in a time-sensitive situation. So, best practice is to explain both options carefully and provide common worst-case examples. And then, most importantly, document the client's decision. So you could consider covering yourself by having the client sign an acknowledgement outlining how their chosen option operates and the cautions you gave them. Occasionally, I do have clients who insist, despite my very careful advice, on a springing power of attorney. So let me give you a real example of how that can create a serious problem. And I'm sure some of you have probably experienced this in your own practices as well. I received a call from a hospital social worker about a client who had been admitted and was now in an advanced state of incapacity due to dementia. The plan was to discharge him into the care of his daughter, who was his named attorney. The issue arose when the hospital needed confirmation that the daughter could manage his financial affairs, so pay for care, arrange services, and so on. They reviewed the power of attorney and found that it was springing, requiring a written medical opinion confirming incapacity. The problem? The client had no family physician, not entirely uncommon at all these days. And there was uncertainty whether any treating physician at the hospital would be willing to provide that opinion. In this case, we were fortunate. A physician agreed. I prepared the statutory declaration to satisfy the terms of the document. But it could just as easily gone the other way. And if no physician had been willing to provide that opinion, the attorney would have been unable to act at a critical moment when decisions needed to be made immediately and in the adult's best interest. That is the practical risk of a springing power of attorney. It can fail precisely when it is needed the most. So, when a client asks for a springing power of attorney now, I always share this story with them.
Yeah, I used to share a story of a client who was quite adamant that his power of attorney be springing, as he didn't trust anyone, only to find himself in the hospital for a number of months after quite a devastating car accident. He was physically incapable, but not mentally incapable, so his attorneys weren't able to do anything for him without a new power of attorney. And somehow it was my fault. My questions to clients after that was, so you don't trust this person to look after things for you while you're capable and can see exactly what they're doing, but you're fine with them taking over and looking after everything when you are absolutely incapable and you can't see anymore.
Okay. This seems rather obvious, but important to point out. An attorney in financial distress. So obviously, an attorney who's experiencing financial difficulty may face temptation and is obviously not the best choice for this role, but I'm constantly surprised by how many clients seem to immediately suggest a very unwise choice for an attorney. So I often ask the client whether the proposed attorney has any indicators such as past bankruptcy, ongoing debt issues, or financial dependence on the adult. So, you know, these questions are difficult, but they should be asked. So where those concerns exist, I recommend against the appointment. So instead, we discuss alternatives. Another trusted individual, perhaps a professional fiduciary, or in very limited cases, joint attorneys, provided the relationship's functional and the document clearly addresses what happens if one can no longer act. But most importantly, I always encourage clients to think practically about who is the best suited to this role, right? Do they live nearby? Do they have the time, especially if the role becomes long-term? Are they organized and reliable? Do they have sound judgment in financial and legal matters? Because this is not just an appointment of trust, it's an appointment of responsibility, right?
Yeah, the best choice shouldn't be based on stroking egos, preventing hurt feelings, or choosing the eldest child.
Of course, we all hear that one all the time. So more on joint attorneys and the conflict potential. Joint attorneys can provide a safeguard against abuse, and a lot of clients initially come in thinking that that's a great idea, but obviously they can also create gridlock. So even when the document includes a dispute resolution mechanism, such as mediation, that often leads to delay and added cost, right, at exactly the wrong time. So in practice, obviously common problems include siblings who can't cooperate, geographic separation, differing views on financial decisions. So for those reasons, I generally advise against joint attorneys, as I'm sure most of you do. And obviously a more practical approach is to allow attorneys to act separately, provided they have a strong, functional relationship, because don't all of our families have that, right? And communicate well. So I usually ask clients very direct questions about that relationship, and I document my answers carefully, right? So neither option's perfect, but in most cases, separate authority offers greater flexibility and fewer obstacles, assuming the attorneys can work together reasonably well. Okay, on to representation agreements. So, common vulnerabilities. By a show of hands, how many of you actually prepare representation agreements?
Interesting. I was curious about that because I'm always surprised by the number of members I've inspected that don't do these documents. Yeah.
So, first off is overlapping authority with other documents. So, this is very obvious to us, of course, but clients often do not understand the different authority granted by a representation agreement and a power of attorney. And that confusion can lead to real problems. So, best practice is to address this directly. Explain the distinction in authority, document that discussion in your file notes, again, so we're going to mention that many times, and also it's always a good idea to reinforce it in your reporting letter. As an added safeguard, again, as I mentioned previously, you might want to consider having the client sign a brief acknowledgement confirming that the differences were explained to them. Because if the client doesn't understand this division of authority, the plan obviously can fail in practice. Next, ambiguous healthcare decision language. So, vague instructions like no heroic measures can be really difficult for decision makers and can lead to confusion. So, the best practice is to encourage clear instructions and guidance, but if the client wants to include really detailed or specific treatment instructions, it's important for you to set boundaries, right? So clarify that you're not a medical professional, avoid advising on any specific treatments, and if the client's really insistent, then encourage them to consult with their physician to develop some appropriate wording, okay? But in my opinion, keep it simple. Representation agreements don't need to be complicated. In fact, unnecessary complexity is often where issues arise. So the key is not length or sophistication, but clarity, validity, and most importantly, suitability to the adult circumstances. So for most clients, a practical takeaway is simple, clear, and compliant is better than complex and clever.
I love that line.
Okay, so now we're going to change lanes a bit and get into the scary stuff, litigation and dispute triggers. Of course, at the top of the list, undue influence and allegations. I'm sure many of you are familiar with the BC Law Institute's guide on the recognition and prevention of undue influence. It's excellent, and I would suggest it should be mandatory reading. But of course, at a practical level, the common indicators we see in files are dependency, isolation, recent changes in relationships. So your best protection is simple and critical. And again, this is echoing what Marnie and Kwan talked about yesterday, but you need to meet alone with your client, right? Not only to take instructions, but as their fact pattern that they covered yesterday illustrated very well, also meet alone with them when they go over the will, right? So, as we saw, the nosy neighbor was being in the room was a bad idea. So I strongly recommend making this a firm office policy, applied consistently and without exception. Just as importantly, communicate that policy to the client from the very first point of contact. So that helps manage expectations and avoids awkwardness at the appointment. So I usually just explain it this way. This is part of our standard process. It's designed to protect you and to protect the people who will be relying on these documents in the future. Because consistency in this practice is one of the most effective safeguards against undue influence. So, Tia, maybe just help me give us an idea what a member could say to clients in this regard.
Basically, I would just say before we go any further, I just want to make sure that these are your instructions and they reflect your wishes. Pretty simple.
And of course, if you do suspect undue influence, make sure that you fill out your BCLI checklist and have it saved in the file. It'll be very valuable to you if you do get called to testify in court.
Great advice.
Okay, suspicious beneficiary involvement. Warning signs are obviously, the beneficiary trying to book the appointment, trying to speak for the client, requesting specific provisions. So again, we're going to repeat this over and over. Your absolute best protection is to interview the client alone. And of course, this is also the best way to assess capacity, right? To ensure that they can answer your questions without anybody else's help.
So what do you do when somebody shows up with those handwritten instructions that someone has given them to help out?
Right, happens all the time. So I thank them for gathering the information to prepare for the appointment, but I explain I'm still going to go through my usual questionnaire just to ensure that I understand the details they've provided and just to get to know them a bit better. So in this way, I then can screen to see if they're able to repeat the information without referring too much to those written instructions. Okay, next topic. So acting for both spouses or partners. So when you're acting for spouses or partners, your first task is to ensure that they're truly aligned in their intentions. So you should be watching really carefully for signs of imbalance, one is doing all the talking or potential undue influence, right? And if there's any hesitation or disagreement, give them time to speak privately. So I actually just had this happen in the last week or so. I thought there was going to be fisticuffs in this appointment, this couple. So, I just sometimes say I'm just going to step out of the room for a few minutes and just, let you have a chat. If that doesn't resolve things, then I've done this many times. Don't hesitate to pause the process and ask them, you know what, we're going to reschedule and have you come back once you've reached clarity between yourselves. Turning to the next stage. So, what happens when one spouse dies and the surviving spouse returns wanting to make fundamental changes to a previously shared plan? Or what happens if there's been a separation? So This is where having a clear office policy is critical. Some practitioners adopt a policy that they will not act on unilateral changes to a previously joint plan unless certain conditions are met, such as the relationship has ended, one spouse has died, or both parties have agreed to the change. And obviously you would want to have some sort of written confirmation of that. So that policy should be clearly set out in your retainer or reporting letter at the outset if you are going to have a policy like this. So for example, you could say, if you later request changes to your will, we may be unable to act on those instructions unless your relationship has ended, one of you has died, or both of you consent to the changes. Setting that expectation early protects both the clients and you if circumstances change later. So obviously this is a personal decision on whether you want to do this or not, but one thing to consider is if the surviving spouse comes in and wants to change the common distribution of the estate, for example, leaving out stepchildren, down the road it might not be a will's variation claim, right? But they could attack the will based on undue influence or capacity after the time for a will's variation action has passed, right? So exactly the fact pattern that Juan and Marnie talked about yesterday. And the reason why I'm pointing this out is I have indications that something very similar to this is potentially brewing on a file I did. And, you know, it's stressful to think that you might be called to court to give testimony. It takes a lot of time when you get a file request and all the things that they talked about yesterday. You know, so just consider that you know, you have to be prepared that this could be something that takes up a lot of your time and energy in the future. And it's, you know, an illustration of why your notes and the quality of your file is so important. If you are going to do that, you better paper that thing as much as you possibly can and try to anticipate, you know, what might I be called upon to remember? What facts about this? You know, how did I make absolutely sure that there was no undue influence or incapacity, and have copious notes on that? Poor documentation of instructions. So if a dispute occurs, the file becomes the evidence. Weak files often contain, as Tia's mentioned, minimal notes, unclear instructions, and quite often missing the rationale for the client's decisions, which is most important. So every time you're doing a personal planning file, assume you may one day be testifying in court and ask yourself, would my notes clearly explain what the client wanted, but most importantly, why?
So we had a number of questions that were submitted to us prior to the presentation. And one of the questions that was submitted was, what do good notes look like for a basic will file? Well, Julia Maka, one of our members from Kamloops, has given me permission to share her notes from a basic will file, with the client's names changed, of course. Now, you're not going to be able to read those, so I'm going to read them out for you. These are good notes. November 28th, 2023, received a phone call from Jane Doe on November 28th, 2023, requesting wills to be made for herself and her husband. Oh, why is that flashing? Okay, we're good. Okay. They've not made wills before. They have one 3-year-old child, own business. They are the only owners/shareholders. No trusts to be set up. He has U.S. origins, so speak about possible issues regarding executorship. Appointment scheduled. December 6, 2023, 10 a.m. Instructions meeting. Clients arrived a few minutes late because it was difficult to find a place to park. This is a young couple with a 3-year-old child. They were referred to me by their financial advisor, Susan Olenek, who has an office here as well. She moved here from Langley after they were married, leaving her hometown. Kamloops is his hometown. They both have horse competition backgrounds. Together, they have a horse training business. They train horses to compete in horse events here and in the U.S. He was born in Kamloops, but has U.S. family connections. He is not a resident or a citizen of the U.S. They are the only shareholders in their corporation and will allow the trustee to deal with the company. I've talked about the corporate structure and advised them if they add any shareholders that they set up a succession plan within the corporate documents so that it's clear what happens to the business if one of them were to die. They asked about powers of attorney and why they would make them. I explained the effect of a power of attorney and encouraged them to make them at the same time as their wills. I explained that if they lose capacity, their attorneys may only be able to do things for them on their behalf. They asked if they could do them later on or in the new year, and I said that they could, but to keep in mind that they must have capacity to do so. Their intentions are to leave all assets to each other, alternately to their children, gift over to children. They are naming one guardian, Jane's sister. The ownership of their ranch/home is shared. His sister owns 55% as tenants in common. This was done so that she could help them qualify for the mortgage. Jane and John are on title as joint tenants on 45% of the property. I will do a title search to confirm. She has a good life insurance policy, which was just set up by their financial advisor. He has a separate life insurance policy. We talked about horses, their business, their other animals, about funeral plans, if any, and if to mention them in their will. They are young people who I advise not to state anything in their wills at this point about funeral specifics. Deposit was paid, signing appointment scheduled. Meeting concluded at 11:24 a.m. December 11th, 2023. Emailed draft copies of will and engagement letter. Title search revealed sister of John owns 55% of their Pritchard property. ILRS abstract report done. John owns this property on reserve land to be transferred to children. Well, we'll see, I guess, won't we? January 12th, 2024. Clients were a little bit late for their appointment due to the cold. They have chores to complete in the morning to look after the horses and the other animals. The cold weather, minus 29 degrees Celsius, makes the tasks more time-consuming. They arrived at 10:20 a.m. with their 3-year-old son, Cole, who is a very active little boy. I reviewed my letter of engagement with them. They both said that they had read their will via email and that everything looked fine. They signed the letter and I scanned it for my file. We reviewed their wills together. Cole was a little bit disruptive, but I did manage to review all clauses with them both, pointing out their choices for executors, guardian, and how they're distributing their assets. John has the added clause in regard to his property, which he owns on reserve in Kamloops. They signed their wills in front of me and Ashley, the receptionist. I scanned a copy into my file, gave them the originals for safekeeping, and made a copy of each for their file. Invoice was paid in full by Visa. Meeting concluded at 10:40 a.m. Wills registered. January 30th, 2024, received registration notices. February 25th, 2024, mailed closing letter along with registration notices. All notes scanned and saved, file closed. Now those are good notes. Now, I'd actually like to ask Julia to come forward and Ron Usher to come up so that he can present the Dunder Mifflin Award for Excellent Notes.
Thank you. Well, so pleased to be here. We have such a congratulations. Of course, we have the traditional Dunder Mifflin Quality Award for your work, so thank you very much. But I also will give you a common red flag. Not just, it's not that good a red flag, actually. And your own inform, explain, and advise, because, of course, what your notes demonstrated is that you informed, explained, and advised your client. So congratulations. And that's all for that. I'll just briefly mention, while I've got your attention, thank you, that Monday night here in Vancouver at Mendoza, we'll be having a special celebration of the 30th anniversary of the NIDAS Representation Agreement Resource Center. I've been on the board for that for a very long time, since 1996. So I just want to really congratulate notaries on your use of the NIDAS registry. You're referring clients to the excellent free legal information and background that's on representation agreements. And really, as noted in the lovely book you got, it was the involvement of Stan Nickel and the Society of Notaries that was a very important part of the development of the Representation Agreement Act, over the objections, I will point out, to the legal community, which is why when the legislation came in, notaries from day one have been authorized to prepare and witness representation agreements. So thank you for your support of NIDAS, and enjoy the rest of the day.
Thanks, Ron.
Thank you, Ron.
All right, back to the fun stuff. Now we're getting into best practices, client interviewing, and capacity assessment. So structuring the initial interview. This is where your file truly begins, not with the document, but with the conversation. The structure of your initial interview is one of the most important risk management tools you have, and yet it's often the most informal part of the process. There's a few fundamentals that should never be optional. We've heard it already, but meet with the client alone, not with someone who might benefit, as Jackie has mentioned and as we know. And it's not situational, it's not discretionary. It's a standard you apply every single time, regardless of how well-meaning or helpful the accompanying person appears to be. And the way you frame it matters. You don't make it awkward, you normalize it. You just simply say, this is part of our standard process, and most people accept that without question. Once you're alone with your client, the job is not to lead the conversation, it's to understand it. So that means asking open-ended questions. Not that, so you want to divide everything between your children, but tell me how you want your estate divided. You're listening not just for the answer, but how the answer is given. As the conversation develops, you need to confirm that the client understands 4 key things. First, the nature and extent of their assets. I mean, we know all this, but not necessarily in precise numbers, but in a way that shows awareness of what they own. Second, who might reasonably expect to benefit from their estate. That includes family members who may not ultimately receive anything. Thirdly, the consequences of the decisions they're making. If they're excluding someone or significantly altering a prior plan, do they understand what that means in practical terms? And throughout all of this, you avoid leading language, because the moment you start suggesting answers, you stop assessing understanding.
Okay, now we're going to talk about assessing capacity in real time. So on the slide, we've listed some of the most critical capacity indicators. As notaries, we're not medical experts, but we have to effectively assess legal capacity, right? Particularly at the time the document is signed. Capacity is decision-specific and time-specific. The threshold of capacity for each document is established either by case law, Banks v. Goodfellow for wills, or legislation for powers of attorney and rep agreements. Sometimes the safest step is simply delaying taking instructions or execution of the documents. Some examples of factors that might make you decide to either pause or decline making or signing documents are client fatigue, emotional distress, inability to describe family or assets, obvious short-term memory loss, and contradictory statements. So you could try a different day or time of day, and you could question whether they've been ill. And often the question is, when should you seek a medical opinion? So you might want to consider this if capacity is borderline, major estate changes are being requested, or there's likely to be conflict among family members. But remember, the test for capacity is a legal test, not a medical test. So if you do seek a medical opinion, ensure the physician understands the specific legal threshold required for the document being made. But remember, a medical opinion is not a silver bullet. It supports your file, but it doesn't replace your judgment. Your best protection is, again, clear, detailed file notes, and your own observations, right? Or possibly information provided by those who know the client really well. And, these are really sensitive situations, right? So if you're worried about offending your client when you need to inquire about competency with their doctor, just simply tell them that you just want to do a good job and make sure that their will stand up in court. Because ultimately, it's your assessment and your documentation that will be scrutinized. And, again, documenting observations carefully is so important. So your file note should clearly record who attended the meeting, the key questions asked, the client's responses, and very importantly, your observations of the client's demeanor. So, where relevant, include objective observations such as personal grooming and any apparent physical or cognitive challenges. And again, I think it's always a good idea to ask a client whether they have any health issues that could affect their decision making. The goal isn't to diagnose, but to create a clear record of what you observed and what the client communicated. And, for those of you who are just starting out in the profession, sometimes it feels uncomfortable to ask these questions, but it's so important, and it's all about how you ask. As long as you do it very respectfully and sensitively, it's your best protection. So I strongly encourage you to overcome those, fears or reservations you might have about just delving a bit deeper. Sorry.
Yeah.
Go ahead.
So the next section is on documenting that intent. Once you understand what the clients want, your next responsibility is to document not just the instructions, but the intent behind them. Detailed notes are really critical here. If a decision is straightforward, then your notes can be straightforward. But when there's a difficult decision or an unusual decision or something that can be challenged later, you need to go further. This can be particularly important if you may have a wills variation issue. It's not sufficient to simply record in your records that those are your client's wishes and make note that you discussed it. The client should acknowledge in writing that they're aware of the legal and moral obligations under WESA and that they still want to proceed. If a client is excluding a child, record why. If they're favoring one over the other, record the rationale. Because at some point, someone could ask, what was the client thinking? And your file should answer that. It should be a record that can stand on its own. Ideally, and as previously mentioned, a memorandum that sets out that rationale would be best practices. It's also good to practice confirming writing instructions in writing. A follow-up letter or a summary can serve as both confirmation for the client as an additional layer of protection for you. It demonstrates that the client had the opportunity to review and understand what was being done.
Yeah, so, and as we saw yesterday with the fact pattern that Marnie and Kwan told us about, that was key in her reporting letter. So, very good advice. Okay, so changing gears, managing undue influence risks. So, capacity and undue influence. All right, so again, we're like a broken record, but separate interviews. So for the reasons Tia and I have already covered, separate interviews are one of the most effective safeguards, but it bears repeating because of the critical importance. I just can't believe how many clients will come in and say, well, they didn't make me do that at the last place I went to.
Yeah.
Really? Okay, well, we do here. Simply part of our standard process, right? Observation of dynamics. So your assessment doesn't begin in the meeting room. It should begin at the first contact. So whether that's the initial scheduling call or an interaction in the reception area, pay attention to dynamics. So who's answering questions on the client's behalf? Who's interrupting? Who appears to be directing or controlling the conversation? These early interactions can reveal subtle indicators of undue influence, coercion, or vulnerability. It's also valuable to ensure your staff are trained to recognize these cues and to, most importantly, to bring any of those concerns to your attention promptly. For instance, your receptionist can be an ideal person to observe conversations in the waiting room between your client and maybe the person accompanying them, and then warn you of those red flags. My receptionist will often come in before she takes the client into the meeting room and just sort of give me a brief rundown of, you won't believe what, their son said to them out there in the waiting room, right? So, and it's great to have that background knowledge as you're going in. So often what happens before you even meet the client can be just as important as what happens during the interview. Neutral explanation of consequences. It's essential that the client understands the practical impact of their decisions. So this often means stepping into a devil's advocate role. So respectfully challenging assumptions and exploring consequences. And that can really feel uncomfortable at times, especially maybe when you're first starting out, but it's such a critical part of our role. Our job isn't just to document instructions. It's to ensure the client has considered the potential outcomes, including those that they may not have anticipated. So if your client is saying to you periodically throughout the meeting, wow, I never even thought of that, you're doing a good job. Mm-hmm. And most importantly, declining to act where appropriate. So sometimes that protects both you and the client. And again, this is something that at least I personally felt was difficult when I first started out. And, some of us can tend to be people pleasers, right? And you don't want to upset someone, and it's very awkward, but it's just so important that you follow your gut, right? So you might need to tell the client, given the circumstances, I'm just not comfortable proceeding today. My role requires me to be satisfied that these instructions are coming directly from you and that they reflect your independent wishes.
So when have you declined to act?
Well, there's a couple of common scenarios that I'm sure we've all experienced where I have declined to act. So one is, I love this one, when a client arrives with family and once you're in the room meeting privately with them and you ask, so what brings you in today? What can I help you with? And the client responds, I have no idea. They just told me I had to come. Like, wow, okay. So then you probe a little deeper, you carry on, and the client is completely unable to explain their instructions or answer your questions with any meaningful detail. So, yeah.
Yeah, I know it can be uncomfortable to tell someone that you can't act for them, but you just need to be respectful and honest. And honestly, in those types of situations, you'll quite often find that those clients already know, or the people that brought them in already know that you're not going to be able to do anything for them, but they're just kind of testing, just to see if it might work.
Yeah, very often. Or there's the classic circumstance where a client says they want to leave everything to, say, the one child that they live with, and further discussion reveals that that child's financially dependent on the client or appears to, be exerting really significant influence over their decisions. So we try to really manage risk in our office by identifying these types of scenarios as early as possible. So to do that, we insist on communicating directly with the client, not through family members, right? So if the initial request for an appointment comes from a family member, we tell them we're going to need to speak to your mom, dad, grandma, and, fill in the blank directly. They need to call back and speak to us or put them on the phone. And then, obviously, if during that first interaction the client mentions that they want to make really significant changes to an existing will, particularly if they say, hey, I want to disinherit one of my kids, we're approaching that file with very heightened awareness. And I just find that this is such an effective tool because it's way easier to decline to act at the outset than it is once you're in the room, right? When the pressure to proceed is much harder to resist, even if something doesn't feel quite right. So just don't put yourself in that position if you can avoid it. Okay, next topic. So risk management and workflow excellence. File management essentials. So when a problem or a dispute arises, and I'm sure Kwan can tell you this, he's seen it so many times, often the issue isn't the document itself, it's the file, right? So the strength of your file often determines whether you're protected if something goes wrong. Good file management protects you, the client, and the validity of the document. So one of the simplest and most effective risk management tools is a standardized checklist for each document type. Checklists help prevent missteps during busy practice days, and they become really powerful evidence if your file is ever scrutinized because they demonstrate that you follow a consistent, defensible process every time. But it's important to distinguish a checklist from an intake form, okay? An intake form captures the client's information and instructions, so what the client tells you. A checklist documents what you did, the steps you took to properly complete the file.
Or I often see a combination of the two in one document, which is also fine, but you need to have both.
Yeah. So in a will file, here's just some examples of what your checklist might include, right? These are things you're just checking off. Capacity considered, client interviewed alone, prior will reviewed. This is big, knowledge and approval confirmed. Peter Ramsey has a box that gets checked off every single time, right? And, if he's ever called up to give testimony and the judge says, well, how do you know the client approved, had knowledge and approved the contents of the will? Well, because every single time I I satisfy myself that they did, and I check this off. You can check off that execution formalities were followed. And so this is where the real value shows up. So if you're ever asked in court, like I said, how do you know the will maker understood and approved the contents of the will? You're not relying on your memory, right? You can point to your checklist and just say, because I followed my standard process and I confirmed it at the time. A checklist doesn't replace judgment, again, but it ensures that the critical steps are never missed. Standardized intake forms. So intake forms serve two important functions. Obviously, they collect information across files, but consistently, right? And they create a written record of the client's instructions. But these forms are particularly useful when you're dealing with complex or blended families because they remind you to consider all the relevant factors, okay? And you know how that is when you get in a meeting with a client and the conversation veers off, because they start asking questions and suddenly, you think, where was I? And so if you have, your checklist or your intake form, and you just look down, I'm not going to skip any blanks, I'm not going to have any blank spots, I'm going to just carry on with my process. So they also help compare current instructions to prior documents. And this helps identify potential red flags early in the process. One of the tools that I use, when a repeat client comes in to update their will, I like to work from their prior intake form. So I use a photocopy, and then I record any new or changed instructions in a different color. So that makes it very easy to identify what's changed, and just as importantly, to explore why. It creates a clear comparison, right, between past and current instructions and helps ensure that any significant changes are intentional, understood, and properly documented. A consistent document retention policy is essential because incomplete or poorly organized files do not protect you. Good file management is invisible when things go well, but it becomes critically important when a document is challenged. A well-managed file should show another practitioner, a practice inspector, or a court to understand what instructions were given, why decisions were made, and how the document was executed.
Yeah, you should always ask yourself if a dispute arose 5 years from now, would your file clearly explain how I reached the final document? Okay, so up until this point, we focused on identifying risk and building a strong file. But it's important to recognize that even a well-prepared file can be undermined on execution day. This is where discipline matters. This is where the process protects you. Execution isn't just a formality, it's a critical control point. Some members use very good execution day checklists to make sure nothing is missed and their process is documented. The first safeguard is ensuring a clear explanation of the documents before everything is signed. Even if you've already had detailed discussions with the client, you need to really revisit the key elements. You don't need to reteach everything, but you do need to confirm that the client understands what they're about to sign, what the document does, and what the consequences are. This is particularly important where there's unusual provisions or decisions that could later be questioned. Execution should never feel rushed. If it does, that's your signal to slow down. The second safeguard is confirming capacity, again, at the time of signing. Capacity isn't something that you assess once and assume continues unchanged. You're reassessing in that moment. Is the client still clear, still consistent, still able to explain what they're doing? If anything feels different from your earlier meeting, you pause, because the validity of the document depends on capacity at the time of execution. And finally, you need to be really cautious with remote or hybrid execution. These processes introduce additional complexity, timing issues, verification challenges, and increased risk of procedural missteps. If you are using remote execution, you must be confident that you're complying fully with the applicable requirements. If you're not confident, the safest approach is to return to an all-in-person process. The main point is this: execution day isn't the time to relax your standards, it's the time to apply them most carefully.
Okay, so now we're going to talk about communication and expectation management. So this is something that we do in our office, and we've really found that it has helped a lot. To avoid wasting your time and theirs, when a client requests an appointment, after you've made the appointment, consider sending an email confirming it, and also covering what you discussed with them on the phone already, which is setting out the types of wills you cannot prepare, right? So even though we have that whole discussion while we're setting the appointment, we follow that up again in writing when we send that email so that they can read through that. We give them scenarios of types of files that we can't do. And, sometimes we have people phone back after they've read that and say, I've been thinking about it more, and what I want falls into one of those categories of wills you can't draft. So then we're not wasting each other's time. Explaining limitations of documents. So clients often misunderstand what documents can do and the difference between an executor, an attorney, and a representative, and how those roles interact, right? So obvious to us, but you have to explain those limitations of each document, often several times, if necessary, even if it seems so obvious to us. I like to refer to the three main documents when I'm explaining the differences as the basic tools the client should have in their estate and personal planning toolbox. So I tell them, once these are properly in place, the right people have the authority they need at the right time to support the client and carry out their wishes. It's also important to clarify storage responsibilities. So discuss with your client who will keep the original documents, where copies will go, and most importantly, clearly document this in your file. And I think you should decide on and be crystal clear with clients on your policies regarding the release of copies in future. So, for example, ensure they're not relying on you keeping a copy in case their originals are lost. So at my office, I'm always telling clients very clearly, my copies are for my files only.
Yeah, definitely keep copies for your file as part of your due diligence, but also as proof of what that document looked like when you left your office. I had a client who had appointed me as his alternate executor in my personal capacity, of course. A number of years later, he stopped by the office with the original will because he had some changes that he wanted to make. My very astute receptionist told him that I just needed to cite the original document first and brought it back to me in my office. We were both horrified to see a document that had not been prepared by my office, was not a good document, but apparently she and I had witnessed it, although they weren't our signatures. The crazy thing is that the only change was actually removing my appointment as the alternate executor. It did nothing else, and they didn't add another alternate executor, but otherwise the document was more or less the same. But somehow this elderly gentleman had no idea that this wasn't the original document that I'd prepared, and I had to explain to him while I was ripping it up in front of him that he was going to have to do a new document. I actually reached out to the RCMP about it because my signature was forged, but they weren't interested until the document was actually put to use. So once I destroyed it, that was that, and he went on his merry way, and I didn't do the other will for him, so I'm not quite sure what he ended up doing.
Wow, crazy. Providing guidance to attorneys and representatives. So attorneys and representatives need to understand their fiduciary duties and their accounting obligations. So I'm sure most of you do this, but in my practice, I reinforce this by having them review and initial a fact sheet or relevant legislative summary outlining their responsibilities, and then I retain that in my file. So it's a very simple step, but it creates a clear record that those duties were explained and acknowledged. Lastly, let's touch on avoiding advice beyond scope of practice. So know what you don't know. So stay not only within your scope of practice, but within areas where you have the necessary expertise. So don't dabble. As BC notaries, we have a professional duty to our clients to represent them competently. So if you're not prepared to do the required due diligence, it's better not to take the work on at all. Because taking on unfamiliar matters without the proper knowledge is where risk and liability begins.
One of the other questions posed by one of our members was questioning about the red flags a notary should identify in the area of multiple wills. For those of you who may not be aware, this is an estate planning strategy to minimize probate fees and increase privacy by creating separate wills for separate classes of assets. So a primary will that would cover assets requiring probate, and a secondary will that doesn't have to be probated, dealing with like private company shares. But multiple wills are a complex area of practice. We had a lawyer provide a presentation a number of years ago at our conference where the concept first came to light, and many experienced notaries came away thinking that it was definitely not an area that they wanted to get into. This is a very complicated area of estate planning that requires the ability to provide advice on corporate share structure. And it's a good example of an area that you shouldn't be dabbling in unless you've got that, unless you get other training that won't be happening here. And here we are full circle, back to inspections, protecting yourself during inspections. Everything we've discussed ultimately leads to this question. If your file were reviewed tomorrow, how would it stand up? Because inspections are not hypothetical, they're part of regular practice. One thing inspectors look for in your file is organization. Is the file structured in such a way that makes sense? Can someone unfamiliar with the matter quickly understand what was done and why? A well-organized file isn't just easier to review, it reflects a disciplined process. And closely tied to that is the audit trail. Can the inspector follow the progression of the file, from the initial contact to instructions to drafting to execution? And are the steps documented in a way that shows logical and careful process? If the answer is yes, then great, you're in a good position. Having a policies and procedures manual is another important safeguard. It demonstrates your practice follows a standardized procedure, that you've established processes for intake, identification, execution, and file management. And just as importantly, that those processes are consistently applied. And finally, self-audits. You don't need to wait for an inspection to identify issues. Review your own files periodically. Look at them critically. Ask yourself the same question an inspector would. Does this file tell the whole story? Because the best time to correct a problem is before someone else finds it. So the key takeaway, if there's one thing that we hope you take away today, is this. Most disputes in personal planning are not caused by complicated legal issues. They arise because something in the room felt uncomfortable, but the process continued anyway. A difficult family dynamic, a rushed decision, a client who seems slightly uncertain, an explanation that doesn't quite make sense. In those moments, the most important skill is not drafting, it's judgment. Good practitioners learn to slow down when necessary. They ask more questions. They document carefully. And sometimes they make the most difficult decision of all. They decline to act. Because the goal of personal planning is not to produce documents, it's to produce documents that will withstand scrutiny years later when the client is no longer able to explain their decision.
All right, so we have a personal practice challenge for you to wind things up here. What's one change that you're going to implement next week in your own office?
Hopefully there's something. Although we do have a little bit more, though. We do have a number of more questions that were submitted online, and we'll try and get through all of those before we run out of time, knowing that everyone's going to want to go and check out and grab their things out of their room. So we'll go through these quite quickly. You go first.
So, question, a member is looking for a will clause that will address cryptocurrency assets. CLE's Wills and Personal Planning Precedents, the annotated guide, includes a clause. It's 20.25, and it deals with digital and electronic assets and liabilities, and it has been updated to include cryptocurrencies.
The next question was, what is your recommendation of the long form and short form representation agreement? Well, my personal recommendation isn't that of the society or the association, but rather my personal opinion. I prefer the short form because in my mind this document is meant to be the appointment of the person. An adult's healthcare wishes can change over time and can be documented on an ongoing basis separate from the document. So again, simple is better.
Question, many notaries and lawyers routinely include the prescribed certificates in their Section 9 representation agreements, although they are not legally required. Is there a recognized best practice or risk management reason for including these certificates in a Section 9 RA? Are they recommended to improve third-party acceptance or for another practical purpose, even though they are not strictly required for validity? So Section 5.4 of the Representation Agreement Act states it's an RA7, right, that is invalid unless each representative completes a certificate in the prescribed form. So there's no such requirement for a Section 9 agreement. Notwithstanding the comment in CLE's annotated guide that states that Form 1, Certificate of Representative, is not required for a Section 9 representation agreement, but we would typically include them. But in our inspections, members are told not to include them because they are not required.
The next question was, by including a standard revocation in a power of attorney, I find clients can get confused as they naturally assume that sentence is the only action required to revoke a power of attorney. What are your thoughts on this? Can we start eliminating the revocation letter sentence in our POAs, or should we be beefing up this paragraph and stating that the previous POAs have had the Section 28 requirements met? And going forward, that to revoke the current power of attorney, the requirements need to be met. Well, you can choose to eliminate the revocation paragraph if you wish, although that would not be my choice. Part of your job is to make sure your clients are aware of what those requirements are. And you should remind the clients of that in your reporting letters as well, which I'm assuming that you all do.
So, next question. When I completed my notary education in the Malls program in 2017, we were told that will makers who have a beneficiary who's on provincial disability assistance must be referred to a lawyer to have their wills drafted so they can have an extended trust will drawn up. However, since then, the ministry has instituted some leniency for assets over $100,000 for people on disability assistance, allowing them 3 months after obtaining the asset to establish a legal trust for those assets. How has the new policy changed the recommended approach for will makers with beneficiaries on disability assistance? So, answer is, I don't know that it has. My understanding is that those will makers should still be seeking advice from a lawyer who can include the appropriate trust clauses in the will, because that's really the only way to be sure, right? Then you're not rolling the dice. Mm-hmm. So that would be what we would suggest.
All right, this member's question. When drafting a will, where there's a possibility of Wills Variation Act application under WESA, notaries are often told our file likely will be requested and we may be asked to testify in court as to the capacity and intentions of the will maker. Certainly, I expect to have to produce a copy of my file. However, can we refuse to testify or provide other assistance? Do we have to testify and provide evidence beyond a copy of our file? If we're retired and no longer in practice, can we be compelled to be a witness? Yes, you can absolutely be compelled to testify in a civil case, even if you're retired. Anyone possessing relevant evidence can be served with a subpoena requiring them to attend court, give evidence, and produce documents. Refusing to testify can lead to a finding of contempt of court, potentially resulting in fines or jail time.
And on the topic in general of providing a copy of your file, just a reminder that your notes are your own, and they're for your eyes only, so they don't have to be given over when your contents of your file are requested. So in the case of a personal planning document, your intake or your instruction sheet, yes, but your notes of your personal observations of that file, you don't have to release those, right? So those are the things that become so key if you're ever called to testify. Oh, sorry. My slide's next. Sorry. Question, could you please provide a good explanation of what this common, detailed income tax elections clause is for, and give some examples of why an executor or beneficiaries would be glad this clause was used in a will? So CLE's Wills and Personal Planning Annotated Guide actually suggests that the simplified version is useful when the estate is being distributed outright on death, because it serves as a reminder to the trustee to obtain tax planning advice and consider making all appropriate elections available at the time of death under the Income Tax Act. And then it goes on to state that the detailed provisions should be used if there may be a beneficiary with a disability or the will contains charitable gifts because of the new graduated rate estate provisions.
And those are all the questions that we had submitted previously. So I don't know if anyone has any really easy questions that they'd like to ask us before we call it done.
Thanks. Thank you, Jackie and Tia. I've got some virtual questions in my cave in the corner
okay.
here. Okay, so is it possible to ask Jackie for the info sheet she gives attorneys, Jackie?
Sorry, can you say that again?
Is it possible to ask Jackie for the info sheet she gives attorneys?
that you
Oh,
give attorneys?
yes, absolutely.
Okay, we'll get that uploaded.
Absolutely, yes.
Excuse me, this is a longer one, so I won't read all the details, but the gist of the question is, it would be great to get clarification if notaries are allowed to draft wills that go against WESA and disinherit children.
I didn't actually hear that.
Sorry, Trista, it's a little bit hard to hear.
Could you repeat that, please?
Okay, it would be great to get clear clarification if notaries are allowed to draft wills that go against WESA and disinherit children.
Well, yes.
Oh, yeah.
We're absolutely
Of
allowed
course you
to
can.
draft them, you know, there's nothing saying we can't, but, you know, just what we recommend is that you have
Good notes.
incredible notes.
Really good
yes.
notes.
You know, that's where you're being more careful than you would on the ordinary file.
Yeah.
Okay, thank you. Last two here, I think. Can we obtain the checklist that you mentioned from Wendy Shum, please? Is that an option?
Absolutely. I'll make sure that gets uploaded.
Thank you.
Thank you to Mickey for that, actually.
Yeah. And actually, there's some really good checklists in the CLE book. I mean, they're probably too detailed for our purposes, but you can always pare them down to the basics, but it gives a good idea of what you should be considering.
Yeah.
Last question here. Do you recommend the reporting letter to list the assets the client has and to explain what happens to them upon death? Joint assets, assets with a designated beneficiary, assets that will become part of the estate and be distributed by the will.
I guess it's never a bad thing to be very clear, but you just want to make sure you know what you're talking about, right? You got to be really careful that you don't put any misinformation in there or anything that could be
Misconstrued.
misconstrued.
Yeah.
Yeah.
Thank you. That's it for online.
Yeah.
Thank you, Trista. Anything else? Could you repeat the question?
Yeah, no, the question was, have I ever recorded an interview with a client that's quite complex? Personally, the only time I've ever recorded it is when it was back in COVID days, and we were doing virtual meetings with clients. So I have those, and I continue to have those recordings. They form part of their file.
And
For the purposes of making notes, I mean, I suppose there'd certainly not be a problem as long as you're disclosing up front to the client that you're recording it, just so that you have the nuances that might be missed in those notes.
And
Yeah.
probably a very good idea to get them to sign an acknowledgement
waiver.
and an authorization. Yeah.
Definitely.
Sorry, I do see there's one last question from the floor, and then we'll wrap things up.
Hello. Hi. Sorry, this is a easy question, hopefully. What are the documentation expectations for signing, witnessing attorney signature only?
For signing, sorry.
Power attorney, I often get a request from outside the city, the POA.
Sorry,
where
it's really hard to hear up here.
Because we've got this noise behind us.
try to speak louder. Documentation expectations for witnessing the attorney's signature on a POA that I did not draft.
Oh, okay. I think there's a couple of different views on that. I've certainly worked with notaries that don't like to, first of all, that don't like to witness the attorney's signature on the power of attorney document that they've drafted where they've taken the adult signature. They don't like to do the attorney's signature as well. I'm of two minds. I've never had that be an issue. And I've never had an issue with taking a signature on a power of attorney document that's just been brought into my office for me to witness. But I'm not just witnessing. I'm still, if someone brings a power of attorney document into me just to be witnessed, I still go through that list, that same list that Jackie's talking about that sets out their responsibilities so that I'm quite clear, that they're quite clear about what they're agreeing to when they sign that document. So I don't think it's a problem. I mean, I don't know if the society thinks it's a problem, but I don't think it's a problem.
Anything else?
Sorry, final question from this side. We had
don't know if
one
this is-
final question from each side. Here we go.
Is this on?
It is.
Yeah.
I just have a quick question in regards to going back to like only meeting with the client. Oftentimes like we practice in Victoria where there aren't as many people that practice in a different language. So for clients where English isn't their first language, what do you suggest to help mitigate factors for having translators come in that say aren't certified translators, but obviously aren't family members or people that might have vested interest in the documents, but what is to stop them from hiring like a friend or something? So how would you mitigate having a translator come in?
Yeah, well, personally, I probably wouldn't do that, Will. And if I was going to, I would insist on a professional translator, and I would investigate and make sure that person is properly credentialed, and I would not allow a friend or a family member to translate. But I'm very risk averse, so I just wouldn't go there at all.
I'm also very risk averse, so generally I would pull up our list and I would look at our members by language that they speak, and I would direct that person to go and see that member, because things get lost in translation. So it's far better that they're speaking with somebody that can understand. They can understand each other. It's a far better situation.
Thank you.
Great. Anything in conclusion?
We're done. Enjoy
All
the
right,
rest of
then.
your day.
Let's thank Tia and Jackie. Notaries, this session is concluded. There's a coffee break now in the foyer, and we will resume in this room at 11 a.m. Thank you.